Lord. I was moving on to stage 2 of the specified prosecutor's task, which is the application of the interests of justice test in section 74.3b. There is, my lords, my lady, a discrete, fact-specific issue in this case, which it might be convenient to deal with briefly first. It's discussed at paragraphs 83 to 88 of our printed case, and it's the question of whether the specified prosecutor simply directed herself by reference to an incorrect test, namely whether the interests of justice required referral rather than merely whether referral was in the interest.
So what are the paragraphs again, please?
That's paragraphs 83 to 88 of our printed
Thank
case.
you very much.
This issue I don't think is expressed in a conclusion in the judgment of the Divisional Court, because even on the specified prosecutor's own case, the court found that she had misdirected herself. But it may be important for this court to consider the issue because, as the Divisional Court recorded at paragraph 61 of its judgment, that's MS 189, my learned friend Mr McLeanan submitted that so broad was her discretion that the prosecutor was entitled to apply a test of necessity to the section 74.3b determination. And in our submission, my lords, my lady, there's an obvious and material difference between something simply being in the interests of justice or being required in the interests or by the interests of justice. The latter test is a gloss on the statute and introduces a test of necessity. Now, the appellant's response to this point was that Miss Atchison's affidavit, and the court will find the relevant extract at MS 375, that her affidavit confirmed that she didn't apply this gloss to the statutory test, notwithstanding that that wording was used on a number of occasions. But as authority shows, such an averment is not the end of the matter if there is a risk that the misstatement of the test influenced the decision, even where there is, as I emphasise there is here, no suggestion of bad faith. And the proposition for that is the Hinton case, which the court will find in the authorities volume at tab 8, that's MS 821. This was the decision of my Lord, Lord Kerr, and it was a challenge to a decision of the Life Sentence Review Commissioners, and they had, in a letter, set out the wrong test which they should be applying in the circumstances of the case. And if the court would turn to MS 827, paragraph 25, my Lord, Mr Justice Kerr, as he then was, said it's not clear why the constraint contained in Article 6.4 should not apply, but it was accepted that it didn't, and therefore that test should not have been referred to. And if the court looks to the bottom of the page, paragraph 28, it's now accepted that the Commissioner's letter wrongly stated they could not direct the release of the applicant unless they were satisfied that it was no longer necessary for the protection of the public that he be confined. In an affidavit filed on behalf of the respondents, however, the chairman of the panel of the Commissioners asserts that this was not, in fact, the test applied by them. So that's what has happened in this case with the specified prosecutor. It's claimed that they decided the applicant's case in accordance with the correct test, and the error arose because the wording was contained in a pro forma letter. Then paragraph 29, while the good faith of the Commissioners and the explanation that has been offered are beyond question, once that error has been acknowledged, it seems to me that the Commissioner's decision cannot stand. They're obliged to give reasons. They gave the reasons, and it's not now open to them to resile from the reasons. And then the final sentence of that paragraph, the likelihood that the explicit statement in the first sentence of the letter played some part in the decision simply cannot be dismissed, and therefore paragraph 33, the Commissioner's decision could not stand. And the evidence in this case...
I mean, hang on a moment. This is, I can very understandable with respect application of a particular approach to that particular case, but my Lord is not stating something. And there's been plenty of discussion in the authorities and indeed in the textbooks of the circumstances in which one can expand on or clarify statements made in the initial reasons. And It all depends on whether what you're saying is actually consistent with what has been said, or whether it's putting up something completely different. But are you saying we simply have to ignore what the special prosecutor said about her approach?
No, my lord. What I'm saying is that it has to be put together with what she said contemporaneously at the time.
Well, I think that's the important question. I mean, in the Hinton case, the letter was unambiguous about the basis on which it was the decision was taken. Here, the specified commissioner, specified prosecutor is saying that although it may read as if she was applying a necessity test, in fact that was just a formula that was being used, and she at no time did indeed apply a necessity test.
Lord, essentially the same affirmation was made in the Hinton case, and the court held that where one, and we say that this applies with particular force here, where we're looking at the transparency of the process and public confidence in the system, where one looks at the contemporaneous documents and one cannot exclude the fact that the erroneous test may have had an influence.
I think we'd better look at what she says about that, hadn't we?
I'm happy to do that, my lord, and I can run through this very quickly, and the court will either think there's a point in it or not.
In Hinton, there was a specific requirement to give reasons in the decision, wasn't there?
That is correct, my lord, and that's not the same feature of the statutory scheme here.
Well, it's an important feature, isn't it? And clearly, if there's a requirement to give a reasoned decision, then you start your reasoned decision. But if you're looking at it in a much broader sense, then it may be a different approach. Anyway,
what we have here, my lord, is, and my learned friend asserts, there is a clearly reasoned decision which he has produced and which he relies upon. So the question is whether a later averment, which is inconsistent with the contemporaneous reasoning, is sufficient to...
Well, that's the issue. Is it really inconsistent with the contemporaneous reasoning?
But Mr. Schofield, you're such a good advocate that you, at first, might seduce us into thinking that required is totally different from in the interests of justice. But thinking a bit more about it, there's only a piece of rice paper between the two.
I'm very grateful for the compliment, my lord, but I respectfully disagree with the proposition. We've dealt with this, my lord, by reference, amongst other things, to, I think it's section 13 of the Coroners Act. And I'm going to take your lordships and your ladyship to a decision which deals with that, because it has a similar interest of justice test, but it recognises that there is a distinction between something being required in the interest of justice and desirable in the interests of justice. And if one imposes a necessity test or reads that gloss in, one is excluding cases where it may be desirable in the interests of justice for there to be a referral, but it's not required.
Well, hadn't we better see what the specified prosecutor said?
Yes, my lord, and I'll take your lordship and your lordships and your ladyship through that quickly. Perhaps would you turn first of all to MS 355. As we know, in our submission, much of this scheme is about public confidence in the sentencing process, and in recognition of that, the Public Prosecution Service issued a press release to describe what they had done in this case, and that's found at MS 355. It's a press release of the 11th of June 2013. Now, at this stage, in fact, until we'd issued proceedings, we hadn't seen the detailed reasoning document which was subsequently produced, but we were alerted to this point because of what the PPS publicly said. And the court will see, just on the penultimate substantive paragraph on page 355, this is a quote from the director, Mr. McGrory QC. He says, if there is a knowing breach, the question then arises whether the interests of justice require that he be referred back. So that's the director propounding in our submission the wrong test. And if one turns over the page to page MS 356, third paragraph from the bottom, after the director has had his say, the specified prosecutor then describes her decision, and the court will see three paragraphs from the bottom. Having regard to all the circumstances, I've concluded that the interests of justice do not require either of the stewards to be referred. So we raised this in our pre-action correspondence. A response came back, and the court can find that at MS 364. I won't ask the court to turn to it, but at paragraph 5b of that letter, the incorrect test is again referred to. But most importantly, I accept, is what the specified prosecutor said in the decision itself when it was disclosed.
What's your reference to the letter, please?
That page is MS 364, my
Thank
lady.
you.
And when we look at the decision itself, an incorrect formulation of the test, whether the interests of justice require referral back, is used repeatedly throughout the document. So if the court will turn to MS 378, we find the incorrect test in paragraph 1, the very first paragraph of the decision. That's MS 378. We find it repeated at paragraph 18. That's MS 381.
Sorry, just look at paragraph 1 again. For the purpose of deciding whether the interests of justice require, yes. I see, right.
First thing she says, my lords, my lady, paragraph 18, she sets out the issue, which is the issue for her to consider. And we see again that once there have been knowing breaches, the question is whether the interests of justice require their discounted sentences to be referred back. So she's directing herself by reference to the wrong test. And we point.
She does say the same thing several times, Mr. Schofield. We can see it. If I'm the specified prosecutor and I ask myself, do I think that the interests of justice, do I think that this case should be referred, or do I think anything else for that matter? Do I think in the interests of justice this case should be referred? If my answer is yes, what's the difference between that and I think the interests of justice require it to be referred?
Well, my lord, as we submit, firstly, the incorrect test introduces a requirement of necessity, which is not
does it?
within the statutory test. Well, perhaps another way of looking at it, my lord, is this. One is starting from the presumption that there shouldn't be a referral unless it is required, unless there's something which pushes you over the line.
I asked the question the other way around. If I think the statutory test is, do I think that in the interest of justice the case should be referred? Is that right?
Yes, my lord.
Right. Well, if I think that it should, do I not also think that the interests of justice require it?
We're back to this distinction, my lord, between it being desirable in the interests of justice and required. And the second is we submit plainly a higher hurdle.
Thank you.
I'm not going to take the court through all of the passages where the incorrect test is set out. But if the court looks at the very first sentence of the section where the reasoning is set out, that's paragraph 236, and then the reasoning section itself from 238 to 262, you will find what we submit as the incorrect test referred to on a variety of occasions, and particularly at paragraph 2494C. That's when the prosecutor is addressing the public interest in transparency and the independence of the sentencing process. Now, we say that's what this scheme is all about. And she says that those factors cannot justify referral where it is not otherwise required in the interests of justice. So we say, when one looks at this decision as a whole, and reading it fairly, as we accept we must, the very few correct references to the test are hugely outnumbered by the references to the incorrect test, and also appear to be included more by accident than by design.
So that submission proceeds on the premise that, in fact, she was articulating an incorrect test. There may be a looseness of language here, but simply because someone says the interests of justice require doesn't necessarily mean that they are opposing a preemptive test of necessity. It would be better, given the degree of scrupulous analysis to which you're subjecting this statement, it perhaps would have been better for her to say, in the interest of justice, I have decided not to refer, rather than the interests of justice do not require, or the interests of justice require. But in ordinary parlance, it doesn't necessarily connote the imposition of a freestanding test of necessity, does it?
Well, my lord, perhaps we can just leave the submission at this. We say that when the decision is read fairly and as a whole, the document reads as if the prosecutor plainly doesn't want to refer the case unless she is utterly compelled to do so.
Well, where is the reference? You don't need to open it to us, but where is the reference to her explanation or her refutation of this point?
Lord, that's her affidavit at MS 375.
Thank you very much.
Lord, so I'll move on. The next issue is, in our submission, whether the exercise under section 74.3b is an exercise of prosecutorial discretion. And, we've dealt with this in our printed case at paragraphs 31 to 39. And the appellant, as the court will have seen, repeats the mantra that this is a species of prosecutorial discretion. It's analogous to a decision as to whether to institute criminal proceedings. We see that at various places throughout my learned friend's case. And in our submission, this is a poor analogy for reasons of both practice and principle. As a matter of practice, as the court will know, the authorities which suggest that review of prosecutorial decisions should be rare rely to a very large degree on the fact that to permit such review would be to allow a collateral challenge outside the trial process to a matter which can be and properly should be addressed by submissions or applications within the trial process. And that objection, we submit, plainly does not arise here. There's no forum other than by way of judicial review for this or any other applicant.
Well, that's okay for decisions to prosecute. Obviously, decisions not to prosecute can't be dealt with by things within the trial process.
Quite so. And for that reason, the authorities suggest that a lower threshold will be applicable where that is the character of the decision being challenged. But perhaps more importantly, and following on from my lady's observation, this decision is simply not a classic exercise of prosecutorial discretion, far from being, as my learned friend suggests, a direct analogue or a prosecutorial paradigm. That's the appellant's case at paragraphs 66 and 79. What's happening here is quite different. It's the exercise of a specific statutory discretion in an entirely different context. And as Lord Steyn reminded us in Ex parte Daily, in law, context is everything. So here, the context is the sentencing phase of the criminal justice process. The decision to prosecute has been taken. The defendants have been found guilty. And the question is whether the sentence is or remains appropriate. And as the comments in the InnoSpec and Dougal authorities on which we rely emphasise, sentencing is classically and constitutionally a matter for the courts and not for the prosecuting authorities. Now, my Lords, many of the appellant's authorities touch on this point. Many say the same thing or repackage earlier dicta. I just want to take the court to one of those authorities, and that's the Sharma versus Antoine decision, if I may, and that's in the authorities bundle at tab 24, commencing at 1065. I know this is a case with which my lady, Lady Hale, will be familiar. It's a case with...
Part of a long saga.
Yes, it's very interesting facts indeed, my lady, but it contains an authoritative statement of the relevant principles, MS 1073. And perhaps I could just take the court to that briefly. So we see at the very bottom of 1073, after some of the principles we've just been discussing, the courts have given a number of reasons for their extreme reluctance to disturb decisions to prosecute by way of judicial review. They include the great width of the DPP's discretion and the polycentric character of official decision-making in such matters, including policy and public interest considerations, which are not susceptible of judicial review because it's within neither the constitutional function nor the practical competence of the courts to assess their merits. And then there's reference in the next paragraph to the objection to satellite litigation, and at Little Roman 5 to the different functions of the prosecutor and the court, which of course we emphasise. But that portion of the judgment emphasises four things about prosecutorial discretion. One, the width of the discretion. Two, that it includes policy considerations. Three, that it includes public interest considerations. and 4, that these are not within the constitutional function or the practical competence of the courts to assess. In our submission, when looking at section 74.3, almost the complete opposite is the case. So the section 74 discretion is not a classic prosecutorial decision because, prosaically, it's not a decision whether or not to prosecute. It's a specific statutory gatekeeping function which happens to be assigned to a prosecutor. There's a specific statutory test to be applied, the interests of justice, which is different from, for instance, the bold wording of section 31.2 of the Justice Northern Ireland Act 2002. Now, the court doesn't have that, but that's our provision which confers the standard prosecutorial discretion on the DPP. It says the director may institute criminal proceedings in any other case where it appears appropriate for him to do so. So this is a separate type of test.
Well, there is a public interest test, isn't there, to be applied in a decision about whether to prosecute?
There is, my Lord, yes.
Yes.
Not here in our submission. I'm about to come on to that.
Right.
The second point we submit is that there is a general policy element to the question of whether a sentencing review should take place. Unlike in cases of standard prosecutorial discretion, where there may be specific types of crime where there is an appropriate policy not to prosecute, this court, of course, will be very aware of the intentions about that in the context of assisted dying. But here, that type of policy consideration doesn't arise. We've already made submissions about the very simple policy of this part of the 2005 Act. But moving on to my Lord Kerr's point, the section 74.3b test is also not, in our submission, a public interest test. The interest of justice, we submit, is a narrower phrase than public interest, and a public interest test is to be found in Chapter 2, Part 2 of the 2005 Order in a number of places. So one sees that in Section 73.4 and Section 74.14, both interestingly in the context of the court examining the public interest in terms of the transparency of its decision-making. But in our submission, the statute advertently disavows the usual public interest considerations whenever the test for referral back is formulated in Section 74.3.
That's a very brave submission, Mr. Schofield. I mean, justice has an enormous public interest dimension, doesn't it?
Of course it does, but it's a narrower subset of considerations, my Lord. The fact that the legislature uses both tests within the same chapter means that a distinction is obviously being drawn.
Well, does it comprehend a consideration of whether a referral back of a particular sentence might operate as a disincentive to others who might be disposed to come forward?
My Lord, I'm going to come on to that, but
the short answer,
the short answer is this, my Lord. The disincentive is against breaching your agreement. The disincentive is against telling lies. If you comply with your agreement,
the short answer is no.
Yes, my Lord. Yeah. If you comply with your agreement,
Miss Aitchison should not have taken into account the consideration that if these two Stewart brothers were referred back for sentencing, that might operate as a disincentive to others.
It won't, my Lord.
But whether it won't or whether it wouldn't, your submission is that has to be put to one side.
Yes, my Lord. The incentive, as the case law says, the sole incentive is the discount in sentence. The disincentive here is against breaching your agreement. And in our respectful submission, it's perfectly proper that that is disincentivized. So the fourth point on this, my lords, my lady, was that the review procedure is about the legitimacy and transparency of the sentencing process, and as we've submitted, whether the discounted sentence remains appropriate. And unlike classic prosecutorial discretion, those issues are neither the constitutional function nor the practical competence of a prosecutor to assess. On the contrary, they are constitutionally matters for the court and the court alone. We do say also, my lords, my lady, that there's a further distinction to be made between the section 74.3 exercise and the more usual prosecutorial decision, which is a strong factor against any restricted form of judicial review. And that is that, unlike the normal prosecutorial decision, in the Section 74 scenario, the specified prosecutor is not independent. The appellant's reliance on the independence of the process, for instance, at paragraph 78 of its case, MS 115, is misplaced. And the reason I say that is because in this scheme, here the specified prosecutor has already hitched their wagon to the assisting offender. They've made an agreement with the assisting offender, and they have been working with the assisting offender. And that gives rise to the temptation or the perception that the prosecutor may be influenced by their own prior dealings with the assisting offender, or for instance, some kind of side arrangement with the assisting offender, or possible criticism of their own office in the circumstances of the case, whether the review is successful, in inverted commas, or unsuccessful. And that's particularly so in high-profile cases of political sensitivity, such as this case was in Northern Ireland. Now, that is precisely the type of concern that the 2005 Act is designed to avoid. So the prosecutor here is not, with respect and with no disrespect to the particular specified prosecutor, is not independent of the assisting offender. So for those reasons,
You might, I mean, the converse problem would presume, the converse risk would presumably exist as well, Mr. Schofield, that having spent a lot of time cultivating the witness, you're likely to be more disappointed if the outcome is not what you'd anticipated. But that would be a reason for not giving the decision to the prosecutor at all, wouldn't it? What the statute does, rightly or wrongly, is give it to the prosecutor.
there has to be a filter, we accept. And as I said before the short adjournment, one of the reasons why it has to be the prosecutor is because they will be best placed to determine whether breaches have occurred or not. But it's a reason in our respectful submission why the discretion afforded should be extremely narrowly construed.
I follow.
So for those reasons, my lady, my lords, the analogy drawn with the classic prosecutorial discretion, we say, is of no assistance to the court, and the divisional court was right to reject it. But finally, on this point, in any event, as Lord Bingham indicated in the Corner House Research case, which is cited in our case at paragraph 32, MS 132, prosecutorial decisions remain subject to review for failure to promote the statutory scheme and for misdirection in law, both of which we say arise in this case, and which were key bases on which the divisional court found for the respondent below. So can I move on then now just to discuss in a little more detail how we say the interest of justice test operates. And we've dealt with that in some detail in our written case at paragraphs 11 to 30 and paragraphs 61 to 77. There's a discrete point which we would emphasise, which the court should bear in mind in construing the statutory test in section 74.3b. It's discussed in our printed case at paragraphs 71 to 74. That's MS 146. And it's this: the point is that the same test applies where the question is whether the assisting offender should be referred back to the sentencing court in order to secure a decrease in sentence in a section 74.2b or c case where new or further assistance has been given after the sentence. The same test applies in that case as applies where an increase in sentence is in prospect. And we submit that where an offender has given assistance after his sentence, it's hardly fair if the specified prosecutor can prevent him from putting that before the sentencing judge in the exercise of some unfettered, unrestrained broad discretion and in circumstances where the decision is effectively unreviewable, which is the logical consequence of my learned friend's submissions. The correct approach in principle we submit, as the divisional court has identified, is that where the factual picture is such that the court could alter the appropriate sentence in the absence of some exceptional countervailing consideration, the court should be given the opportunity to consider that, whether the result may be the sentence being increased or decreased. So that brings me on to what the divisional court held.
I mean, where there have been knowing failures, you would always have to say the sentencing court could increase the sentence. So if that's the criterion, you're straight through, subject to the countervailing considerations.
Well, my lord, no, because at that first stage, as the divisional court held, the specified prosecutor can and should assess whether the knowing breaches are such that the court the material circumstances have altered. So I think we mentioned the example earlier on of an assisting offender who, for a period of days, withdraws cooperation. That's a breach of their obligation to give continuous assistance. But after 2 days, they relent. And in fact, in this case, it's interesting, when the Stewart brothers were coming up before the parole board, they threatened at one stage to withdraw cooperation and then were talked back into compliance. But in a situation like that, where there has been a breach, it's had no material effect whatsoever. Full assistance has been given when required. The specified prosecutor is perfectly entitled to say, and this is consistent with the divisional court's judgment, the material circumstances here have not changed to such an extent that the court could consider that to be something which it needs to relook at. Those will only be in the very clearest of cases, we accept, but it is not the case, as my learned friend submits, that once there's a knowing breach, referral must necessarily follow. There are 2 chances for the prosecutor to say that's not required. A, if the court couldn't properly consider that the material circumstances had changed, or B, if there are countervailing circumstances which the divisional court leave at large to cater for the exceptional case. All of that arises out of the divisional court's treatment of this issue at paragraph 56 of its judgment. That's at MS 187. And I just want to say something briefly about that. The appellant criticises the divisional court for propounding a rigid test in this section of the judgment. But in defence of the divisional court, if one reads paragraph 56 carefully, the court explains that it is simply discussing principles which are helpful in understanding how the prosecutor should approach the interests of justice test. So if the court looks at the opening sentence of paragraph 56, the second sentence, we consider that this analysis about new circumstances is helpful in understanding how the prosecutor should approach the interests of justice. And then just over the page at the top of page 188, it is with those principles in mind that we examine the approach of the prosecutor in this case. So it's a discussion of relevant principle or statutory context or constitutional context. It is not proposing to set out the test which must be applied in every case. That's clear because the court says we're now turning to examine what happened in this case. Now, I accept that there is an obvious requirement to focus to some degree on this issue given the terms of the question which was certified by the divisional court. But we do caution this court against an undue focus on paragraph 56. In our submission, paragraph 62 is equally important, if not more important, because there we see in the final sentence of that paragraph that the determination, or the final 2 sentences, the determination of the appropriate sentence by the court is an important constitutional principle, secures the confidence of the public in the administration of the criminal justice system. In our view, it could not be undermined by statute other than by the clearest words. And it is that totally unexceptional application of the principles of statutory construction which lead to the result in this case.
Well, I mean, that's a crucial question. The court is there saying, well, forget about the precise words of the statute. We have to treat it as having read into it implicitly this overriding constitutional principle, and therefore we treat that in effect as part of the statutory scheme. Now, if that's right, I can see where you go, but where do you get that from? The idea that you can rewrite a statute to include a principle which the Parliament hasn't stated. Respectfully
say, my Lord, that one is not rewriting the statute, one is simply construing the statutory test in section 74.3. And the Divisional Court does that against the background of the statutory purpose, which I discussed at the commencement of my submissions, and this fundamental constitutional principle, which is expressed in a variety of cases that the court will be familiar with. So what we say about that, my lord, is that the Divisional Court was entitled to explain the statutory scheme and to construe the Section 74(3) test in light of the statutory purpose. That is what it has done. That is all that it has done. Just as the Divisional Court in England and Wales construed a similar phrase in the Coroners Act 1988 in the Hillsborough inquest cases. And I wonder if we could just ask the court to turn to that briefly.
But your defence of paragraph 56 has been a little cursory, and you bid us look in particular at 62. One of the problems for that, Mr. Schofield, is that at 63 and 64, the court comes straight back to the 56 analysis.
I accept that the court does go back to that, my lord, but the simple reason why it does so is because what the Divisional Court is saying, in perhaps overcomplicated terms, is that the specified prosecutor here has simply missed the main point. The main point is, as I hoped I outlined to the court in my submissions before the short adjournment, where the position as known at the sentencing stage has radically altered. Constitutionally, the court should be given an opportunity to either say, in light of that, the sentence needs to change, or, just as acceptable, in light of that, the discount should remain, and here's why. And all of the points that my learned friend makes as to reasons why the specified prosecutor should not send the Stewart brothers back to court are points that can be made by her or by them to the sentencing judge. And if the sentencing judge says, I've heard those submissions, I can't be bothered wasting time about this, of course the sentence will stay the same, then the case will be dismissed and no harm is done. I want to take the court to the authorities at tab 9, just very briefly. This is the Hillsborough inquest case. The case begins at 829. It's MS 829, and the relevant paragraph is paragraph 10 at MS 833. And I hope it will become quickly apparent why we say this case is of assistance. So paragraph 10 at MS 833. The court here, this is a divisional court, it says, we shall focus on the statutory language as interpreted in the authorities to identify the principle appropriate to this application. The single question is whether the interests of justice make a further inquest either necessary or desirable. So there's the recognition there of two separate tests, but there's a single question. It's about the interests of justice, just like this case. The interests of justice as they arise in the coronial process are undefined, as in this case. But dealing with it broadly, it seems to us elementary that the emergence of fresh evidence, which may reasonably lead to the conclusion that the substantial truth about how an individual met his death was not revealed at the first inquest, will normally make it both necessary and desirable in the interests of justice for a fresh inquest to be ordered. Now, one can take that unpacking of the statutory test and apply it in the context which we're looking at in the present appeal. What the Divisional Court here has found is that it is elementary that the emergence of new circumstances, which might reasonably lead to the conclusion that the initial sentence was not appropriate, will normally make it desirable and necessary in the interests of justice for a sentencing review to be ordered. They're conducting precisely the same type of statutory analysis and construction as was the Divisional Court here. And actually, the parallels are rather striking, because the court goes on here to say, what is more, it's not a precondition to an order for a further inquest. This court should anticipate that a different verdict to the one already reached will be returned. If a different verdict is likely, here, if a different sentence is likely, then the interests of justice will make it necessary for a fresh inquest to be ordered.
I think it's extremely difficult to compare the two situations, Mr. Schofield. I mean, in this case, a completely different outcome in terms of verdict was anticipated. Here, the outcome isn't going to be different. They're still going to be guilty of the offences to which they have pleaded guilty. It's merely an adjustment of the sentence. I think to transpose this from an entirely different context to the present case is extraordinarily difficult.
Well, it's a matter for your lordship how helpful this comparison may be, but in our submission, each statutory scheme is about allaying public concern. What is said here is that even if an inquest confirms the original result, that is to be viewed as something which is plainly in the interest of justice.
Well, yes, but don't forget that inquests, I absolutely understand why you say that there's a parallel to be drawn, but inquests are about establishing the cause of death, are they not? That's the historic function. The original inquests in Hillsborough, the jury had been directed that they were not required, indeed allowed, to make a decision about how the deaths had occurred. There had never been a decision. It wasn't so much that there was a possibility of a different decision. It was that there was a need, or so it was held, a need for a first decision.
Lord, I should say, a little like my learned friend with the exercise of prosecutorial discretion, I entirely accept the analogy is not perfect.
Yes, fair enough.
I'm using this as an instance where a similar phrase, the interest of justice, is construed by the court, and the court says this is what it means, this is practically how it will be applied. Okay. That's all the divisional court has done in this case, and there's nothing exceptional in our submission about that at all. The further objection, which is raised by both Mr McGleenan and Mr Lavery, is that insofar as the divisional court's approach results in a prima facie presumption of referral back, where there has been a knowing failure to give assistance, and then it's said that that is a disincentive for those who might agree to become assisting offenders, or in Mr McGleenan's phrase, there may be a chilling effect. As I've said in our submission, we say that's utterly wrong. The incentive for them is always and remains the discount in their sentence, a presumption of referral back, if that is indeed what the divisional court's judgment provides for, is simply a disincentive to assisting offenders from breaching their agreements, and for our part, we can't see why that would be a bad thing. My lords, my lady, I think my time is probably up.
Nearly. You've got another about 4 minutes.
Consider how
it is being benevolent.
I am being benevolent, yes.
I'm very grateful.
But you've had quite a lot of attack.
Perhaps I'll try and split the difference.
But if you feel that you've had enough time, well, by all means, sit down.
Well, my lords, my lady, I wanted to address the issue of materiality briefly, and in particular the essential position of the specified prosecutor, which we say has no expression or anchor in the statutory scheme, that the only really important lies are lies which falsely implicate an innocent individual or are determinative of the outcome of the trial. We say that that is the specified prosecutor rather than the divisional court reading in a gloss and restrictions on the statutory test, and we say those were plain misdirections. In any event, on the issue of whether the lies told in this case were determinative, we refer again to Mr Justice Gillen at paragraph 247, where it's clear that all of the lies that he found had such an effect on credibility that they all together resulted in the dismissal of the charges. I think I've already made our point about the specified prosecutor's characterisation of a successful referral being low, and we say that's plainly a misunderstanding of the statutory scheme, as the divisional court held. The issues of the extent of the assistance given by the assisting offenders and the time which had elapsed from the time of their sentence are dealt with in paragraphs 89 to 93 of our written case, and I think I can stand on our written case in those respects. Finally, if insofar as necessary, we do contend that this was a perverse decision in the circumstances of this case. The Stewart brothers, as the court has seen, were sentenced for a veritable litany of offending, including the most heinous of crimes. They received an exceptional level of discount in the circumstances I addressed at the start of my submissions. The trial judge who assessed the so-called assistance they gave to the prosecuting authorities was utterly excoriating in his criticism of them. It's common case that they broke their agreements. Little or no value, we submit, came of their evidence, and on the contrary, as the Northern Ireland Director of Public Prosecutions accepted before a committee of the Northern Ireland Assembly, the whole affair damaged public confidence in the justice system, and the court will see that at MS 346. And my lady, my lords, in those circumstances we say it is beyond logic. Indeed, one might even go so far as to say it is immoral, that the appropriateness of their reduced sentences should not at least be open for transparent reconsideration by the independent judiciary. And we ask the court to dismiss the appeal.
Thank you very much indeed, Mr. Schofield. Mr. Sayed? Mr. Lowry.
Lady, my lords, as an antidote to the very long judgment of Mr. Justice Gillen and the long specified prosecutor's decision, I'll offer a very short reply. I only want to deal with one or two points. Firstly, we suggest that the court should adopt a high-level principled approach to this case. There is a danger because of the involved facts and the specific idiosyncratic nature of this case that principles can emerge which are skewed somewhat, and we say that's what happened with the divisional court because of the irregular or unusual judge-alone trial, the extensive judgments and the reaction to that by the specified prosecutor. At the level of high principle, we say there are a number of constitutional lines in play. One is the importance of the sentencing function, which the respondent relies on in this case. The other is the need for an independent examination of the issues by the prosecutor. And we reject the contention that the prosecutor is not independent in this context. The case presented by my learned friend focuses on the sentencing paradigm. That's the way in which their case is presented, at the expense of any proper consideration of the role of the specified prosecutor. The metaphor chosen to illustrate what they say is the approach that should be adopted by the specified prosecutor is the sieve with very large holes. The last occasion Mr. Schofield, Mr. Loughlin and I were here in this court in December, we spent several days listening to the metaphor of the conduit pipe being debated. I suggest the sieve with large holes should be consigned to the same drawer as a utensil only to be used in emergencies, because it, of course, is an instrument of no utility. In this case, the real suggestion is the specified prosecutor has no real scope to prevent a referral, save for very, very limited cases. The only illustration given by a learned friend was the situation where someone wobbles for several days. Anything other than that would amount to something that required referral back. And we say that's a wholly inadequate consideration of the statutory scheme as designed by Parliament, which gave a much fuller function to the specified prosecutor. The issue is taken again in this case today with the misdirection or wrong test being applied by the specified prosecutor. That was a point which did feature quite prominently at first instance, although there's very little treatment of it in the judgment. It was an issue that emerged because of the press release that had originally been put forward by the Public Prosecution Service in this case. When we came to hearing in this case, of course, we had the benefit of two things. One was the decision itself, and the other was the affidavit of the specified prosecutor. And her affidavit, MS 375, directly avers, paragraph 19, that she at all times was aware of the correct test to be considered. She said it was a test she considered, it formed the basis of my decision, and she refers to a number of specific passages in the decision itself, which she says illustrate that she applied the correct test. Now, my learned friend did take you to various passages in the decision document, but not to the passages that she herself relies upon. Paragraphs 22, that's page 382, where she recites accurately the statutory provision with the interest of justice test. Paragraph 35, where again she recites accurately the test in 74(3)(b). And then, perhaps most importantly at all, in paragraphs 251 and 262, which are her conclusions, that's page MS 421. Paragraph 251, having carefully considered all the issues discussed above, considered the matter in the round, I've concluded it's not in the interest of justice to refer the discounted sentence back. So her ultimate conclusion correctly applies the language of the statute. The same is true at 262, which is her conclusion in respect of Robert Stewart. So in the final analysis, when she reached her conclusions, she accurately and appropriately used the statutory language. In any event, we say that insofar as she has on occasion used the word required, that is no more than a reflection or a formula for her to express that she thought the interests of justice required referral in those cases. So we say there's nothing in that point, and it was rehearsed before the divisional court. The court did not actually make a finding in respect of it, and we say there's no evidence of a misdirection in this case. In terms of the response to the chilling effect argument, the line that my learned friend adopts is interesting. He says the only incentives that really matter here, and the incentive that arises from referral back, is that it will discipline those who are within the scheme to faithfully adhere to their agreement. And we would accept that there's a value in that, to ensure that those in the scheme adhere as best they can to their agreement. But that will only bear fruit in public interest terms if there are entrants to the scheme in the first place. And if the scheme is operated in such a way that there are structural disincentives to ever participating in it, that internal discipline will be meaningless. The critical factor is whether or not the erosion of the specified prosecutor's discretion and the presumptive referral arrangement that flows from it will in fact prevent assisting offenders engaging at all. And we say that at the level of principle is the concern that flows from the divisional court's judgment.
Mr. McLean, you just then used the phrase in the public interest. In fact, of course, what we're concerned with is the phrase in the interests of justice. There must be a difference between those two.
Yes.
Could you sum it up? I'm not sure I could, but I'm going to ask you to.
I'm not sure I can either, but
Yeah.
One may include the other, of course.
one can embrace the other.
Well, the public interest would all obviously include the interests of justice.
Yes.
The other way around is...
What we're certain about here is the administration of justice is broader than the sentencing function. My learned friend's focus is on the sentencing function. The administration of justice is a broader concept than that. It contains within it public interest considerations. So there are coexisting within the analysis of the administration of justice concerns about the sentencing function, the integrity of the sentencing judge's role, but also the wider public interest in ensuring that the uneasy compromise of an assisting offender scheme continues to function. Because that has a reduction in criminality in itself a public interest consideration. And the problem with the analysis put forward by my learned friend on behalf of an acquitted defendant, understandably, is that they take a much narrower conception of what the administration of justice requires. Sentencing retributively of those who they say have failed to honour their agreement ignores the wider context this scheme was designed to embrace. Lady, my lords, unless I can assist further, those are observations.
I think not, Mr. McLean, and thank you very much indeed, and thank you to everybody for their very clear and very economical arguments orally, not quite so economical in writing, but we're grateful to every word of them. And we shall, of course, now go away and consider what our response is to those arguments and let you know in the usual way. Thank you. The court is now adjourned.